Jan Rivers is Genspect's New Zealand spokesperson, a former public servant whose roles were in information management, library services, and information policy. She is also a lesbian, an activist on public issues, and works part-time as a meditation teacher. In 2018, she recognised gender ideology as a threat to the public sector, to social cohesion, and to women, children, and same-sex attracted people. She helped found some of New Zealand's gender-critical organisations and is the author of articles on the impact of gender ideology on government and the dangers to children and young people of gender medicine. Jan will talk about the current review of the protections in the Human Rights Act 1993 for people who are transgender, people who are non-binary, and people with innate variations of sex characteristics. The review has not met the usual standards for creating an issues paper, including failing to determine any of the terms used in the review and adopting a gender ideology world context for the arguments. Welcome, Jan. Jan, please go ahead.
Kia ora koutou. Thank you very much for the invitation and the opportunity to talk about this very prescient topic. I've got some slides, so I'll move over to those shortly. But pretty much that's a good introduction of me. What I'm going to talk about really is not so much what my recommendations for the legal issues paper around including transgender, non-binary and people with innate conditions of sex development, but rather to talk about the nature of the issues paper and some of the reasons why its poor quality has made it very difficult for feminists and people who may not be entirely supportive of that proposal to respond to. So I'll just share the screen and then I'll get started in earnest. So I'll just give you some background first of all. The issues paper is open for 12 weeks. The consultation closes on the 5th of September. In theory, the nature of an issues paper is that it allows for competing rights and interests to be weighed. It says that in the document. So the Law Commission is a relatively recent creation of New Zealand's sort of public constitutional infrastructure, if you like. It's a part of government that the government itself can ask to do investigations of new novel law when law has become outdated, or when there are other problems or issues. It's sometimes used as a way of kicking a difficult issue into touch, and there's an element of that, I think, in the fact that the Law Commission has this paper. What else is there to say about the Law Commission? It's a small unit in government. It's probably under-scoped for what it needs to be able to do. And this current work has taken, I think, about between 18 months and 2 years. And it started off as part of the, as I mentioned, a great way to kick a difficult issue down the road. There have been several attempts to include transgender people in the Human Rights Act over about 20 years. The first was initiated by the transgender MP Georgina Beyer, I think in about 2007, 2008. But the recent attempt has sort of had its origins in the aftermath of the Christchurch mosque attack. And what happened there was that the Royal Commission, which took place in the aftermath of that, didn't actually suggest anything really about other kinds of hate speech, but it did suggest that there needed to be legislation for hate speech. The government took that proposal and proposed that there would be legislation for hate speech about all of the protected characteristics in the Human Rights Act. In my view, the Minister for Justice, Kiri Allen, she was the Labour minister in the last government, she asked the wrong question, and the wrong question for a number of reasons. First of all, there's a great deal of difference between people with conditions of sexual development, physical, medical conditions, and transgender and non-binary people. And in a way, they've been put together in an artificial way to suggest that there's some kind of common ground. The Human Rights Act, the way that the piece of work was proposed was simply to check whether transgender and non-binary people and intersex people were covered adequately by the Act. So there was no attempt really, and that's one of the real problems with this piece of work. There was no attempt to determine whether women's rights would be undermined by action in order to cover the rights of these other groups. And so to a large extent, the paper really doesn't concern itself with that. And we're in a funny situation in New Zealand, which is that since 2006, when Georgina Byers' private members bill was removed from Parliament, the situation has been covered by a Crown Law opinion. And that Crown Law opinion said that transgender and transgender people were covered by the sex-based provisions in the Human Rights Act. But that was a real piece of political brinksmanship, and it was a way of taking the private members bill off the agenda. And one of the things that the Crown Law people didn't do was to look at whether there are any reasons why transgender people should not be covered by the legislation. And there were such cases, but they didn't bother to look at them. And the one that I'm aware of is a case called Bellinger versus Bellinger. And it said that although self-perceived gender might be a relatively good idea to cover in one context, such as allowing marriage, it might not be appropriate in another, such as competitive sport. So all of those other pieces of case law which were looked for around the world, which might have argued for caution, none of them were taken account of. So that's sort of where we are. I've mentioned a little bit about what the Law Commission is. This idea of looking at novel legislation, reporting back to government on a proposal, doing some in-depth consultation, but it doesn't really gauge opinions across society. It only gauges the opinions from the submissions that are provided to it in the form of responses like the process that's open at the moment. And that's where one of the real problems occurs, which is that our gender identity community, if you like, is funded to the extent of probably $10s, $20, $30 million a year through funding to NGOs, to government, from the private sector into genderist organisations. And that's not the case for the women who might want to respond and to ask some more nuanced questions about the wisdom of responding to the Act. And another thing that's an issue for New Zealand is that the Public Services Act, which I think came in about 2 or 3 years ago, has some provisions in it to say that all chief executives must take account of diversity, equity, and inclusion. And what that's meant is that they have really not done a huge amount around other issues like new migrants or people with disabilities. Certainly nothing much to do for women, but it has meant that gender organisations have been invited into the heart of government. As far as I'm concerned, the way that the issues paper has been written is quite different from what we would expect an issues paper, a sort of serious, legally written issues paper to do. But it just follows on from what's been happening in New Zealand for the last maybe 7 or 8 years. And that is that when there's gender based and by gender identity based policy or legislation, what the government does is it appoints a group of self-interested people to work on the topic. So there's never any diversity across the issues. There's always one group of people from gender identity-based organisations and so-called rainbow organisations who get to really call the shots. And that's been the case in at least half a dozen consultations in the last 5 or 6 years. And there's also been the situation within New Zealand where sometimes government just makes policy without any consultation whatsoever. So, for example, the definition of women as self-identified took place within the Ministry for Women without any consultation, policy work, or anything else. And the same applied to our anti-conversion practices legislation. There was no kind of white paper process. There was just a petition that such a piece of legislation be enacted, and it was. So, what did the Law Commission do? It didn't really meet the usual standards for issues papers. I've looked at some of the historical ones, and they are all very carefully written. They all have definitions. They all have a glossary. They use very standardized, very accessible language so that people, whichever side of the debate they're on, can understand it readily. They don't have views that are prejudicial to one side or other. And because, of course, if you're thinking about new legislation, you're obviously very often talking about groups of people with different interests that need to be balanced. But that's not the case with the Law Commission issues paper. It uses views and ideas that are very prejudicial to women's interests. The questions that need to be answered are often very leading questions, kind of saying, well, what should be done that's good for transgender and non-binary people? And there are no questions which really lend themselves to kind of explaining why you might think that's a problem. There is some text in the depth of the document suggesting that they want alternative views, but it's fairly low on the priority list. And the process has addressed every section of the Act, including insurance and superannuation conditions, which were specifically put in place for men and women to be dealt with differently. For example, with insurance, because women tend to live longer than men, and because men tend to be not such careful drivers, and even those sections have been suggested that transgender and non-binary people might want to adapt those sections for themselves. So what all of this means is that women who are very poorly resourced have to do all of the heavy lifting to make the case that there be a different view than a gender ideology view. I'm repeating myself here slightly. The language is incredibly ideological. So women in this paper are are spoken about as cisgender women. It makes it very, very hard to understand actually what's being written about. And it makes it very difficult to believe that our concerns or the concerns of wider New Zealand are being taken seriously when the language is extremely off-putting to be able to respond to. There's no evidence, for example, in the text that I've read through pretty much the whole thing, that, for example, service providers who might be impacted by the need to provide services under this Act have really been consulted. There is certainly no indication that any concerns they have been addressed. The paper makes a whole lot of claims that don't really stand up to inspection. There's no information at all about the demographics of the transgender and non-binary community as far as the paper's concerned. It's one sort of joined up community, it's not a community which is rapidly increasing amongst young women and young people generally. So, and the same applies to the innate conditions of sex development. There's no real explanation that such people are not, by and large, either on a male or a female development path. So it creates this kind of cloudy impression of two groups of people who kind of sit between the sexes. Doesn't do these definitions. That uses the terms like legal sex, but it doesn't define it, which might have been useful. It refuses to define gender identity. It doesn't describe gender as a synonym for sex. It describes it through the lens of gender ideology. And it also has a whole series of really quixotic decisions about what's in and what's out of scope, which I'll come to a bit later. Like it's excluded really gender medicine from being included in the scope, and yet it clearly is. And one of the real biggest concerns about if gender identity and gender expression or transgender and non-binary is included in the legislation, it has impacts on quite a number of areas of legislation. For example, our film and video classification scheme would be affected, and it would mean that any film that addressed transgender and non-binary medicine, for example, from the perspective that maybe it's not a good idea, would be subject to complaints that might mean that they would have to be withdrawn, or that they would have some kind of, hazard assessment made against them, which is, that's this the law has quite a lot of impacts beyond the Human Rights Act. The issues paper describes core gender critical beliefs as if they were kind of strange and unusual. So, for example, a core gender critical belief is that sex is binary, innate, and immutable. Not that that's a belief that's held by probably the majority of the population. And it's a belief of gender critical women, according to the issues paper, that our rights are being diluted by a focus in public policy on gender identity. And it's a belief of only gender critical women that having a gender identity separate from one's biological sex is an expression of an ideology. So these are kind of quite, they're, they're kind of wrong. They don't really capture gender critical beliefs. They express them in a way which is obviously intended to be pretty disparaging and also marginal. Yeah, the issues paper also goes well beyond the well beyond what it's intended to do. So, for example, it suggests that that even other gendered language, which doesn't impact on the provisions that would need to be put in place, according to the paper, in order to cover transgender and non-binary people, that even those gendered expressions be taken out of the human rights law. One of the other things that it does is the only reference to CEDAW is a reference that says that that transgender women are covered by CEDAW, not women in general, and that those things that needs to be taken account of in the provision of a new law. And that's, yeah. So there's some pretty difficult stuff in there. There's a whole chapter on discrimination, and I won't go into a whole lot of detail, but almost half of the references are highly questionable by the nature of the kind of claims that they make. And I'll just look at one of them, a couple of them. One of them is the survey of transgender people, which has been done by the Transgender Health Lab at Waikato University. And that research, which is described as, the best that there is in New Zealand, it results from a self-selecting survey, and it uses leading questions, and it asks, and it kind of uses techniques that that probably double the level of distress, suicidality, and so on that is present amongst the population. It asks leading questions, and in the write-up, it makes causal claims about the things that are like, for example, suggesting that greater mental illness is caused by discrimination, when it's simply not possible to make those kind of causal claims about what's called a cross-sectional survey. It's just one of the things you don't do. And then another one right down at the bottom there, Morgane Auger, a transgender woman in Canada, is described as part of an extremely vulnerable and marginalized population. And a case that Morgane, I don't know how to pronounce the name, but was taken by him, resulted in a $55,000, $55,000 or $65,000 fine and costs. And yet it's well known that this person has been an enormously confrontational person in the Vancouver area towards the Vancouver Rape Crisis Centre. So we've got somebody described as massively vulnerable who actually has been a huge problem to women in the area that he lives in. This is just a little example of something from Counting Ourselves. And it's about quality of life. Has your life got better or worse since you identified as transgender? And the question that's listed actually doesn't doesn't even ask the right question, and yet somehow magically it comes up with a result to show that most transgender people, 65% of their lives have got better. So it's a kind of pretty shonky piece of research. The next thing I want to talk about is there's nothing in the paper that talks about what's happened in Canada, in Australia, in the UK, where legislation that protects transgender and non-binary people has been enacted. And it just seems to me that if you're going to enact that legislation, you actually want to work out whether you're suddenly going to be criminalising or punishing or taking to court people who are doing things which they have previously been able to do quite legally. And of course, that also impacts on being able to talk about, for example, gender medicine. It also impacts on, for example, being able to speak the truth about somebody's sex. It also has impacts potentially in people having the freedom to disbelieve in gender ideology. And I think it's quite important that we can disbelieve in gender ideology in the same way that we might disbelieve in any kind of religious practice. Yeah, that's one of the areas that's not been covered. And then another area is that there's a very, very close relationship in the legislation between our Health and Disability Commission legislation and the Human Rights Act, which the issues paper almost completely ignores. And it appears to me that one of the concerns that is really present is the idea that there is an apparent attempt to embed gender medicine as a legal right, even as the evidence for it is being found to be very poor. So there's no discussion in the issues paper of our conversion practices legislation, even though there have been multiple vexatious complaints, and there's been a really chilling effect on counsellors and doctors about doing other than gender affirmation. Yeah, that's really what I wanted to say. It's an incredibly difficult paper to respond to because of the way that the issues have been framed. And I'm going to hand over to Janet now. But one of the really powerful things that I think that some of the people who have responded has said have been to say that the level of social discohesion, if you like, between women and transgender people is so difficult, it's so problematic, there's so little discussion, there's so much silencing, that it's really going to be unwise to implement this kind of legislation until there has been a more public discussion and until there's been something which allows a broader range of people to kind of consider what actually might work, rather than putting a whole group of people in the frame of kind of what could be very very damaging legislation in terms of freedom of speech, freedom of thought, the right to speak the truth about who we meet and who we see. So that's me. Thank you very much, and I hope I haven't gone too far over time.
Thank you very much,
dear,
Jan.
I think I
know women will have lots of questions, I'm sure. Thank you so much.